Much of our work is in litigation against the United States, multi-billion-dollar litigation against the United States that many of you are familiar with. It also includes the opioid litigation that Emily just noted. And it's been an honor to represent Indian tribes through so many battles over the years. Today, we'll be talking about the Camp Lejeune water pollution litigation. It's of particular importance to Indian country because of the extraordinarily high participation rate of Indian people and Alaska Native people in the armed forces. I think, as you probably all know, Indian people participate 5 times the national average in the military. There are close to 25,000 active military Native Americans today, and close to 200,000 Native American veterans, which is what makes today's discussion so important. You're going to hear from several people from both law firms, and I'll let them introduce them one by one. And I think the next person you'll be hearing from is my colleague Amanda Saunders from our Anchorage, Alaska office. Amanda?
Yes, Amanda, if you want to do a quick introduction, each panelist, name, where you're located, and the firm that you're with.
Hi, my name's Amanda Saunders, and I'm an attorney with Sonosky Chambers in our Anchorage, Alaska office.
Annie?
Hi, everybody. I'm Annie Wanlitz, an attorney with Leaf Cabraser in our San Francisco office.
And Whitney, are you still on here? Yes, there you are.
Yes. Hi, everyone. I'm Whitney Leonard. I'm a partner with the Sonosky Chambers firm based in our Anchorage office.
Elizabeth?
Greetings, everyone. My name is Elizabeth Cabraser from Leaf Cabraser. I'm one of the founding partners of our firm. I'm in our New York office today, but I'm spending much of my time these days in the Eastern District of North Carolina, near Camp Lejeune, where the Camp Lejeune water litigation is being prosecuted. I was appointed by the court to serve as one of the co-lead counsel for plaintiffs in that litigation, and it's been a priority of mine ever since the litigation got going in earnest last summer.
And last but not least, Wilson, who we will also be hearing from first after I give a quick introduction about the webinar's purpose and what we'll be covering today.
Sure, my name is Wilson Dunleavy. I'm a partner at Leaf Cabraser's New York office.
Thank you, Wilson, and all of our panelists. Today's webinar will be focused on sharing information about the Camp Lejeune water pollution litigation and the unique claim and litigation statute that is a part of that. This webinar and the slides will be available after we finish. I am recording and we'll be able to send that out for anyone that wants to pass this information on to other community members or attorneys, or just look back at it for resources. We hope you will have enough information to share with tribal Marine veterans after this and their families, and with tribal veteran associations. While we would like to represent tribal Marine veterans and their families, the purpose of this webinar is to share information, particularly about the August 10th, 2024 claims deadline, which you will hear more about. The webinar topics that we're going to be discussing are the Camp Lejeune Justice Act's history and claim eligibility, the claim process, and filing a case if that's necessary, and the status of the litigation itself. Please hold all questions till the end, but you can drop them into the chat. There is a Q&A box. You can type them in, and then we will answer those questions after we hear from our last panelist, Whitney Leonard, and we'll try to address all that we can. If you do have questions later after the presentation, feel free to reach out anyone speaking today, and we will get you answers as quickly as possible. Now I'm going to pass it off to Amanda Saunders.
Thanks, Emily. I'll start with a little background on the Camp Lejeune Justice Act, which was signed into law by President Biden in 2022. The act created a federal cause of action which allows anyone harmed by exposure to contaminated water at Camp Lejeune to sue the federal government if they meet certain eligibility criteria, which we'll cover in this presentation today. The federal government first discovered that the water at Camp Lejeune was contaminated in 1982. But despite discovering this information, the government did not notify Camp Lejeune Marine veterans or other individuals who lived at or worked on the base for nearly 20 years. An independent federal agency has now stated that the contaminants in the drinking water at Camp Lejeune likely increased the risks for cancer, birth defects, and other health-related problems. These contaminants include industrial solvents from dry cleaning operations and volatile organic compounds from underground fuel storage tanks, industrial spills, and waste disposal sites. The passage of the act itself resulted from years of efforts to recognize what happened at Camp Lejeune and to provide relief for those affected individuals. As Lloyd mentioned, Native American and Alaska Native individuals have historically served in the armed forces at higher rates than other groups. And we anticipate that there are many Native veterans who are impacted by the Camp Lejeune contamination and may be eligible to bring claims. I'll now turn it over to Wilson Dunleavy to discuss that eligibility information in more detail.
Great, thanks, Amanda. So the eligibility requirements under the Camp Lejeune Justice Act, or the CLJA, are as follows. The first requirement is a time requirement, that is how many days a claimant was at Camp Lejeune from 1953 until 1987. As the slide indicates, in order to state a claim, a claimant has to have spent at least 30 days at Camp Lejeune between August 1st, 1953 and December 31st, 1987. These do not have to be consecutive days. So for example, if these could be Marine Corps veterans who have served at Camp Lejeune. These could be civilian employees who have worked at Camp Lejeune for 30-day periods, or these could be family members who visited either veterans who worked at Camp Lejeune or employees who worked at Camp Lejeune for a total of 30 days over that long period. The second requirement is that a claimant must have an illness caused by exposure to the toxic water. Now, under the Camp Lejeune Justice Act, any illness can qualify. The question is it an illness that was caused by the exposure? Now, the federal government, their Agency for Toxic Substances and Disease Registry, that is the ATSDR, has a website listed on this slide that discusses a lot of these illnesses, which we'll also talk about in a further slide. But broadly speaking, as Amanda's already mentioned, there are lots of cancers that have been linked to the contaminated water at Camp Lejeune and other defects. The third eligibility requirement or issue that we'd like to talk about is that you can bring a claim on behalf of a deceased loved one who meet the criteria that I've just described. The parties are still working with the court to determine how to demonstrate what a legal representative means in this context. So that's a little bit unclear, but that should not deter anyone from bringing a claim on behalf of a deceased loved one who has spent 30 days at Camp Lejeune over this period and has an illness caused by the exposure to toxic water. The fourth issue, as I've already alluded to, is claimants do not have to be or have been service members. Again, family members who visited the base, who lived on the base, or other civilians who meet the basic criteria can file a claim. And the last issue we'd like to point all of you to is there are a lot of websites regarding Camp Lejeune. If you Google Camp Lejeune, you'll be inundated with endless websites, some of which purport to be official websites. There is an official website that was set up by Plaintiffs' Leadership Group by order of the court, and that website is www.camplejeunecourtinfo.com. That's maintained by Plaintiffs' Leadership Group. It's updated to reflect the current state of the litigation and any issues. And so that will be an invaluable resource for any claimants or potential claimants wishing to get further information about the state of the litigation. And with that, I'll turn it over to my colleague, Annie Wanless, who will discuss the claim filing criteria.
Great, thank you, Wilson. So here we have just a list of conditions that someone might have to bring a claim under the Camp Lejeune Justice Act. But as Wilson explained, this is a non-exclusive list. You'll just need to show a connection between your disease and that water. With that, I'll move to the next slide, where I will explain how you actually bring one of these claims under the Camp Lejeune Justice Act. The key thing to know is that the Act requires a two-step process. So you first need to file an administrative claim with the Navy, and then you can file a lawsuit. The administrative claim is the first step, and the Navy has set up an online portal, the link is at the bottom of the slide there, where you can submit a claim. The government is taking the position that all claims must be submitted by August 10th of this year, so that's coming up. And that's just for these administrative claims, not the lawsuits that I'll talk about in a moment. To submit a claim, you need a few key pieces of information, namely the time that you were at Camp Lejeune, the disease you've been diagnosed with that you believe was caused by the water there, and you'll also need to list the amount of money you are claiming. So we strongly recommend talking to a lawyer before you submit a claim. It's a pretty straightforward process itself, but everything that you put on the claim form can limit your potential recovery. So we think it's just a good idea to make sure you're talking through what you're putting on that form before you submit it. And after you do submit the claim, the Navy can respond. They can approve it, they can deny it. What we've seen really happen is that the Navy is not saying anything. And after 6 months have passed since you submitted your claim, you can then file your lawsuit in the Eastern District of North Carolina. So Emily, if you go to the next slide, I'll talk a little bit more about that lawsuit process. So the Camp Lejeune Justice Act gave the Eastern District of North Carolina exclusive jurisdiction to hear Camp Lejeune Justice Act claims. And there are 4 judges in that district that are hearing all of the claims. Very early on in the litigation, they appointed the Plaintiffs' Leadership Group that we've mentioned a few times now, and of which Elizabeth Cabraser from our office is part of. So the Plaintiffs' Leadership Group oversees the litigation on behalf of all plaintiffs and manages, motions for summary judgment, discovery issues, those sort of issues. And the court has decided that it will hear cases by track. So it picks about 5 diseases per track. The parties work together and then submit these diseases to the court for approval. And the tracks are roughly correlated to the strength of the evidence connecting that disease to the water at Camp Lejeune. The first 5 diseases in track 1 are bladder cancer, kidney cancer, leukemia, Parkinson's, and non-Hodgkin's lymphoma. And the court has stated that it wants to hear trials on those diseases this calendar year. After trials on those diseases happen, we would move to track 2, which includes prostate cancer, kidney cancer, lung cancer, liver cancer, and breast cancer. Right now, they're focusing mostly on discovery for some bellwether plaintiffs in track 1. And at this point, I'll hand it off to Elizabeth Cabraser herself to give you more of an update on the litigation and its progress so far.
Hello again. Thank you for joining us and visiting with us on this webinar. And for those who've served in our armed forces, thank you for your service. This litigation that we're speaking of is an attempt, although it's a belated one, by the United States to clear a debt that it owes to those who served or worked at Camp Lejeune from the 50s through the 80s, and their families and loved ones, for exposing them to contaminated water that can result, and in thousands of cases has resulted, in diseases, including serious cancers that would not otherwise have occurred. For years, veterans were denied benefits for these diseases. Congress, in passing the Camp Lejeune Justice Act and other legislation, has acknowledged that these are service-related, that benefits should be provided to the veterans, and has also provided a path toward compensation in court for those who were exposed and suffer from or have died from these diseases. The litigation is proceeding in earnest. It's been underway for about a year. You heard about the Camp Lejeune Court Info website. All of the orders and the hearing transcripts and the motions and the briefs are on that website. It's updated daily. There's also information on that website for an early settlement offer by the Department of the Navy. It's very limited offer. Many people don't qualify for it and have not wished to seek it, but that is really a prelude to a more important effort that is being undertaken at the direction of the court to reach a global resolution of all of the claims for all of those who have filed a claim by what the Navy says is this August 2024 deadline. And so I want to reiterate that. It may sound strange that after years and years and years of avoiding the problem and finally recognizing it and providing for compensation, there's a relatively short deadline to get into the claims process. But nonetheless, the government has taken that position, and so we are urging people to be cognizant of that deadline and to get their claim in. That doesn't mean that anyone is committing to file an actual lawsuit or litigate, but it gives you the opportunity to file a suit or to participate in a global settlement if that claim has been submitted. What we are doing in the active litigation with respect to the approximately 2,000 active lawsuits that have already been filed in the federal court in the Eastern District of North Carolina is to set up what's called a bellwether trial system. Because in order to reach a global resolution and to provide a system of fair compensation payments to all of the veterans, the government has said that it needs the guidance of trial verdicts, trial outcomes, some third party, a jury, or in this case, a court, to say what is fair compensation for a particular disease, so that that data can be expanded, extrapolated to reach a system or a matrix of fair compensation for everyone, without everyone having to go through their own individual trial. The court has recognized that if it had to try thousands and thousands of cases, it would be a never-ending process. Veterans are older now, many have died, many are very, very seriously ill, and so neither they nor the court system has the time to wait through all those trials. So instead of doing that, the court has devised a system with the cooperation of plaintiffs, and in this case, the government, to select a set of representative cases to go to trial. We call them bellwether trials. And at this point, as was mentioned, those trials will begin later this year. We don't have a specific trial date yet, but we'll get trial dates very soon from the court. What we have done is we have agreed with the government to a selection process for the track 1 diseases that you saw on the slide: bladder cancer, kidney cancer, leukemia, Parkinson's disease, and non-Hodgkin's lymphoma, or NHL. The plaintiffs are picking 3 plaintiffs with each of those diseases. The United States is picking 2 plaintiffs with each of those diseases. So there will be 25 plaintiffs in all, representing those 5 track 1 diseases that will go to trial before the judges of the Eastern District of North Carolina beginning later this year. We hope, and the court has told us, that those trials will be speedy trials. We don't have to prove the liability of the United States, and this is important. Veterans who file claims and then file lawsuits in the Camp Lejeune litigation, in a very real sense, are not suing or attacking the government. They are taking the government up on an offer and acknowledgement the government has made that it is responsible, it was responsible for the contamination at Camp Lejeune. That contamination, which harmed the earth and harmed the people that lived and worked and served on it, has been corrected. And now the government has agreed to take the necessary step to finish the job, albeit after the fact, to make good for what happened. And so many service members have said that they served loyally, they still are loyal, they love a country that hasn't always loved them back, and they don't want to sue the government. And as we've explained, this is not a typical suit against the government. The government is finally standing up and saying, this happened, we did this, and now we are providing compensation. And it is providing an opportunity for those who served to also stand up and say, I was there, I did serve, I have been diagnosed with this disease because of that service and exposure. So it is on both sides. It's on the side of the government. It is a debt of honor that must be paid. And at least in our view and the view of the plaintiffs we are representing, it is a path of honor to stand up and be counted and be included in the litigation. And we hope that those who were there, who were unfortunately impacted by exposure and who suffer from any serious diseases as a result, will participate. I don't have any specific status information to share with you today about when the trials will start, but the Camp Lejeune Court Info website will have the trial dates prominently posted, and it will have information on the outcomes of those trials as soon as those occur, and it will also have information on progress toward a global resolution so that everyone who has submitted a claim to the Navy will be able to participate in that resolution, whether or not their case has proceeded into an actual lawsuit. And I'm going to pass this on to Whitney Leonard.
Thanks, Elizabeth. So I'll just give a brief summary to wrap us up, and then we'll turn to questions. So again, to summarize, individuals who think they may be eligible to file a claim have to start with the administrative claim process that Annie described, file an administrative claim with the Navy before they can file a lawsuit in federal court. And the government is taking the position again that all claims have to be submitted by August 10th, 2024. So if you're pushing this information out to veterans in your tribe or tribal veterans associations, that's the key deadline to let people know about, August 10th of this year. If the Navy denies the administrative claim or does not respond for 6 months, which is what's been mostly occurring, then the individual can file a lawsuit in federal court. Our firm, the Sanoski firm, and Leif Cabraser together will be representing tribal clients who are interested in filing a claim and joining the litigation. So for anyone who's listening or for others who receive this information, please contact us if you have any questions, either about eligible claims or the claim filing process, regardless of whether you're referring someone for representation. We're happy to provide information about everything we've talked about today. Contact information is listed on this slide, and all of these slides will be posted on both firms' websites. And I believe we should also be able to email them out to attendees if that would be helpful for folks. So I think with that, I will just pass it back to Emily to lead us into questions.
Thanks, Whitney. We don't have any questions in the chat yet, so if you have questions out there in the audience, go ahead and type them in now. I do have a couple of questions set aside myself. And This first one will go to Elizabeth. How much money has the government set aside to resolve these claims?
That's a great question, Emily. There isn't a settlement fund per se. There isn't a sum certain that has been set aside for the claims themselves. When the Camp Lejeune Justice Act was passed, it had to go through, budgeting process and a budgeting report. But we are having to construct the money that would be available and would be payable to pay claims through the process of negotiating a global resolution with the Department of Justice, which represents the United States. And that is why the parties are relying on verdicts or judgments generated by bellwether trials for representative diseases to provide examples of what compensation would be awarded by a Camp Lejeune veteran with a specific disease who went to trial, so that we can use that data to build out a system which would compensate similarly injured individuals with similar diseases, similar ages, similar circumstances, with reliable and predictable compensation awards. So it would be very simple if I told you, there was X $1 billion and there are X thousand or tens of thousands of claimants, and that's how a settlement would work. But we don't have the answer to that yet. And we're working from both directions, the direction of trying to negotiate a global settlement for everyone, and the direction of generating specific trial verdicts to inform that process. But again, and I'm going to sound like I'm stuck on repeat here, in order for people to have an opportunity and a choice to participate in a global settlement or an individual settlement, or to go to trial, or to make any of the future decisions to be made under the Camp Lejeune Justice Act, the one thing that the Department of the Navy has told us needs to be done by August 10th, 2024, is to submit that claim on the Department of the Navy portal. And that gets the claimant into the system so that their claim, or eventually their lawsuit, can participate, be considered in a global resolution or a trial. And as we've said, it's not an onerous process. It's something that requires a little bit of thought. It requires some specific information. It is a good idea to work with a lawyer to do that, although it was also designed so that if it's August, August 6th, and you suddenly realize, or someone and they suddenly realize I need to submit my claim, it can be done online, and you could get into that system, which is the threshold necessity. But again, if you see a website, a lawyer's website or any website that solicits, saying, there's a settlement fund, act now, et cetera, the sense of urgency is real. But the only thing about that really is real is the urgency to get the claim into the system. It doesn't mean, that a check for compensation is going to go out, by return mail or online. There's much more of a process involved. But again, this we're told, and I hate to go on about this, but I think it's important for people to have the context. We're told that there really won't be a serious movement on the part of the Department of Justice toward a meaningful global resolution until this claim deadline has passed, or what they are calling the claim deadline, because at that point, they can at least calculate how many people are in the system, what diseases those people have, and the very, very basic demographic information about the claimant population that will enable the government to start the process of really budgeting for a resolution, right? If they don't know how many people they'll have to pay, it's much more difficult to do that. And so I think what's going to happen by the end of the summer, if I can optimistically predict, is that once this claims date has passed and the Department of Justice has run the data and we have the information on who is in the system as a claimant, then the process of negotiating a global resolution will accelerate. We know that the court has interviewed several very, very experienced, very sophisticated experts to serve as what is called a settlement master, basically a supercharged mediator to help the parties to craft a comprehensive, sophisticated, fair, and transparent global resolution. But again, what the government is telling us they need to know is they need to know who's in.
Thanks, Elizabeth. The next question, maybe Wilson, you want to take this one? And that is, will filing a claim affect my VA benefits as a claimant?
No, filing a claim will not affect your VA benefits. I think this goes to the point that Elizabeth made earlier. The government is acknowledging that they behaved badly and that they contaminated the water. So this isn't a case where the government is going to be penalizing or otherwise looking down upon anyone who is filing a claim. This is a recognition that they did service members wrong and that they recognize that, and through the legislation at least would like to compensate injured veterans and their families for their injuries.
And if I could just chime in for a second on that, as was mentioned, the Camp Lejeune Justice Act was part of a very comprehensive veterans recognition and veterans rights and benefits legislation that was passed by Congress in 2022 at a time when, as we've all heard, Congress was bitterly divided and Congress was unable to do anything by way of meaningful legislation, but yet through bipartisan efforts, Congress was able to come together, from the most conservative members of Congress to the most liberal members of Congress, to overwhelmingly pass this legislation. It was the singular achievement of Congress in 2022. And a fact that that singular achievement of a divided Congress was to unite to recognize the service and the rights and the needs of veterans, I think is something that ought to drive home, I think, what Wilson has said, that this is a singular opportunity. It, for the first time, created a federal tort claim, right of action that didn't exist before. And it did so specifically for the Marines and the employees and the families at Camp Lejeune.
Thanks, Elizabeth and Wilson. Let's see, maybe Annie, you could take this one. So what sort of evidence do you need for a claim?
Good question. There are two key pieces of information you'll want for a Camp Lejeune claim: medical records and military records. I'll talk about military records first, actually. Obviously, at some point, it will need to be clear that you were at Camp Lejeune, but the government has actually said it will take the first pass at trying to figure out where you were and when you were there, because all of that should be in their possession. That said, if you have anything else that would show you were at Camp Lejeune, such as photos from your time there, diary entries, anything like that, it would be good to get that all in one place, along with any service records you have that would place you there. The second piece is medical records, and the key piece of information you want there is just evidence of your diagnosis of the disease that you believe was caused by the water at Camp Lejeune.
Great. Amanda, would you like to take this one? Will lawsuits be necessary, or can a person get compensation just based on the filing of a claim, assuming that the claim was not denied?
So I think I'll defer to Elizabeth on that one in terms of the next steps on the claims process.
Okay, let me give that a shot, because the simple answer is we do not believe that the filing of a lawsuit will be necessary for everyone to participate in a global resolution. Some claimants are being offered settlements by the Department of the Navy now, just based on their administrative claim. Those criteria are more limited, but there is information on the website about that early settlement program. You have to file a claim or submit a claim in order to participate in that if you wanted to do that. But just to put this in perspective, there are nearly 200,000 claims that have been submitted to the Department of the Navy already. Of those, only about 1,800 have resulted in filed lawsuits, because the Navy has 6 months to decide whether to accept or deny your claim. If it does nothing within 6 months, you can then file a lawsuit. Of the approximately 2,000 lawsuits that are on file in the Eastern District of North Carolina, most of them are not active. So it's not as if you go through the claim process, nothing happens, the Navy doesn't give you an offer, or the Navy denies your claim and you file a lawsuit. You're not in the middle of active litigation. The only cases that are being actively litigated at this point are those 25 Track 1 bellwether cases that I talked about. Those are the ones in which there's ongoing discovery, they're being prepared for trial, there are experts involved, and that work is being done by the plaintiffs litigation group, of which I'm a member. And we do that for those 25 representative lawsuits so that all the other lawsuits can be essentially stayed. Nothing is happening in them. People don't have any obligations to go be deposed or go be witnesses right away. And again, as I say, what the hope is that most claims and most lawsuits will never have to be activated. That what will happen is there will be a global resolution. There will be, the necessity to provide some information in that in order to qualify for a claim or be paid. But we're hoping for most people, for most of the claimants, this will be a very simple, straightforward process based on information and records that either they have or the United States has by way of military records.
And next question is a follow-up off of that, Elizabeth. Is there a limitation period for filing a lawsuit after your claim is denied or after the Navy does nothing for 6 months with your claim?
That's a matter of debate and dispute among the parties. If 6 months passes without activity, you certainly can file a lawsuit after that point. There's language in the statute that sets up the sequence of events and the positions that the parties are taking on limitations periods. We're about to post that on the Camp Lejeune the Camp Lejeune courtinfo.com website. So people will have that guidance, but those are not near-term events, unlike the August 10th, 2024 claim date that the Navy is saying is a deadline to get into the process.
Great. Annie, what is the claim, or what do I need to bring for a claim on behalf of a deceased loved one? So again, what type of evidence would you need for a loved one that is deceased now and you're seeking compensation for that?
So essentially the same information that I referenced before, medical records and military records. It's been a bit of an open question what additional documentation you need to show that you are the proper legal representative under the Camp Lejeune Justice Act for your loved one. Very recently, just a week or so ago, the government agreed that you do not need to have an estate open in order to file that administrative claim. We're still waiting for more guidance from the court about exactly what you might need later. But for this point and for the purposes of that August 10 claim deadline, you do not need to have really any additional documentation. Just showing that you are, stating that you're filing on behalf of your loved one. And at some point you might need additional documentation, but that's still being worked out.
Right. We filed a motion with the court to ask for decisions on a number of different scenarios in terms of whether or not an estate had to be opened, if it did, when, which states' laws apply. This is a new statute, and so our court is basically making the case law on it as we go along. But what we know now, and we're very glad to find that the Department of Justice agreed with us and the court agreed with us, is that you don't have to go to the effort and expense of opening an estate to submit the claim with the Navy and get into the Camp Lejeune process. Everyone recognizes that these exposures happened many, many years ago. Estates may have been opened and then closed for people that died years ago. And in many other cases, of course, there would be no other reason to open an estate. And so the court is cognizant that we shouldn't be demanding unnecessary expense, unnecessary delay, unnecessary effort on behalf of the families and survivors of Camp Lejeune people simply to get into the claims process and be eligible for relief.
Great. Two last questions. The first one would be, what is the elective option? And this may be a better question for Elizabeth as well.
The elective option is that early settlement offer that I mentioned that was made by the Department of the Navy, I think in fall of last year. And if you go to Camp Lejeune courtinfo.com, you'll see a notice. It's a very prominent notice tab, and that notice is the notice of that option. The requirements of payment under that option are set forth there. Also, the position of the plaintiff's leadership group regarding that option is set forth there. But in simple terms, for certain diseases, the Navy is offering payments ranging up to several $100,000. The problem with that offer is, which sounds great, the problem with the offer is that the exposure period is longer than the statutory 30-day minimum. The offer is made only for one disease, and many, many people with a serious cancer have other serious cancers. The problem with Camp Lejeune contamination is that it was a gateway to developing often several types of cancer and other diseases, but this early option will only pay for one. And there is a heightened latency period. The disease had to be diagnosed or manifested within a certain number of years of exposure. So for many, many, many valid claimants, it doesn't fit. And for those whom it does fit, their claims may be worth more than that. That said, there are people who are in dire financial straits, who don't feel they can wait out the litigation or wait for a global settlement, who may feel that this is a reasonable offer for them. Not many people have taken it, but some have. Every 2 weeks, the court asks the Department of Justice to report on how many offers have been made and accepted under this early option. And so far, it's in the dozens, not the hundreds or the thousands. And we are hoping and working toward a global settlement that is much more comprehensive, much more reasonable, much more inclusive, and much fairer than the early option. But it is there, and we recommend that people who are in dire financial straits, in dire health, take a look at that and see if that is something that would work for them.
Thank you. This might take a little bit of parsing, so keeping in mind we have about 9 minutes left in the hour, we'll see how far we get and if we should follow up with another question. This one is, who will be able to see filed claims? In particular, will medical records become public once a claim is filed?
Oh, okay. Medical records are protected by a protective order. They're protected by federal statute. When you submit a claim to the Department of the Navy, that does not expose medical records or other personal information. That's protected by HIPAA, that's protected by federal statute, that's protected by a very specific protective order that exists in this case. If and after you file a lawsuit, if there is discovery and if you are selected for trial, then there may be partial disclosure of those medical records. So for example, at this point in the litigation, out of all of the hundreds of thousands of administrative claims and several thousand filed lawsuits, the 25 plaintiffs who are the bellwether trial plaintiffs are the plaintiffs who are subject to ongoing discovery. They will be presenting their medical records to the court. Again, there will be measures in place to protect that evidence. It's not going to be on the internet anytime soon. And of course, those plaintiffs have agreed to serve as bellwether trial plaintiffs. So this is a situation in which you have the decision-making right and control over your medical records and other sensitive information. In global settlements, when medical records are necessary to document or prove a claim, they are also subject to protective order. And the claims administrators and other court-designated people that review those are also under strictures to maintain privacy. And so those don't become public records, even though they are part of a settlement process.
Thanks, Elizabeth. We have time for one more question if anyone in the audience wants to drop that in the chat. I'll give you a softball, Elizabeth. What happens, or maybe not, maybe it's not a softball. What happens if you miss the filing deadline in August?
We don't know, and I am hoping we do not have to find out. That is a date that the Department of the Navy has said is a deadline. If we have to litigate that issue, we have arguments. We've already made some of those arguments under the statute for why that might not be an absolute deadline. But it's really not a good idea to test that because we don't know what the outcome would be. So we take very seriously this August 2024 date. It sounds harsh because so many years of contamination, so many years of silence, so many years of non-disclosure, and then all of a sudden there's a statute, there's litigation, and whoops, there's a deadline date. But it's something that I would really prefer that we didn't have to test for people, that they've gotten their claims in. We certainly would go to bat. As I say, I think there are good arguments for why that is not a jurisdictional deadline under the statute. But statutory interpretation is up to the court. And this is a new statute, so we don't have direct precedent under it. And, you know, that's an unknown territory that, as I say, on behalf of certainly anyone we would represent as clients, we would not want to have to traverse.
Okay. Thank you, Elizabeth, Wilson, Annie, Whitney, Amanda, and Lloyd. We're going to wrap it up now. Mado, thank you for attending. Those in the audience, this webinar and the slides will be available on the Leaf Cabraser website and the Snosky website. We can also email it to you as well. There's some email addresses up on the slide. But please share this information with tribal members, tribal veteran groups, tribal in-house council, leadership. Share it with anyone else that might be a good contact for getting this information out. And also contact us if you have any questions. Thank you for joining. And Lloyd, any parting words before we sign off?
No, I just want to thank everybody for doing what they can to get the word out. It's very difficult, but many tribal communities have community bulletin boards, town hall meetings. We are happy to attend by video any of those meetings. And of course, you can replay this webinar at any of your community meetings. Thank you.
All right, and that concludes the webinar.
Thank you, everyone.